Good evening, everyone. As of late, we have started a lot of discussions on the arbitration because we have seen that a lot of young students and lawyers plus the judges are very keen on the ADR's part. And therefore, with the continuation of that effort, that there should be sensitization amongst the people regarding the arbitration. We had requested Payal Chawla, who is an advocate and founder of Juscontractus. On a very topic, we find that there's a lot of debate going on as to what is the difference between the seat versus venue, or whether there is any actual difference between the two. This is that journey of legal empowerment, which we'll go through today's session. For good 5 minutes, Payal will take across what is intended. And today we thought that why not take today's session in a Q&A form. All those who are watching us live on the YouTube and those who joined this chat box through the Zoom meeting can also ask any question. They can post it on the chat box. We would be happy to take those questions as Payal has agreed. Over to you, Payal, and thank you for accepting our invitation.
Good evening, everybody. I'm Payal Chawla. I will be talking to you today on the aspect of seat and venue, which is a very, very controversial issue. It appears, on the face of it, it shouldn't be controversial because venue, as has been explained in the judgment recently by the Supreme Court, seat essentially means where the supervisory jurisdiction of the court is, where the court decides the applications with regard to Section 11. It could be with regard to Section 9, could be Section 34. Venue is only a place where the arbitration is conducted. So on the face of it, it shouldn't appear this complicated, but in fact, it does get extremely complicated. And this is because primarily there are at least, and I'm using this word at least very carefully, there are at least 4 laws that impact an arbitration. The first law is the seat of arbitration, which is where the parties have decided that our seat will be X place, then that law of that place will apply to an arbitration. There's also the law, which is the law of the main contract, which is also known as the lex contractus. There is, many of you who practice arbitration would know that in an arbitration, the arbitration contract is separate from the main contract. So there is a law that governs that arbitration agreement. For example, under Indian law, that would be the Arbitration and Conciliation Act of 1996. This is known as the lex arbitrae. Then in cases where you have institutional arbitration, you have the rules of that particular institution that would also apply. For example, if there was a Nani Palkiwala institutional arbitration, one would have the Nani Palkiwala rules. This is known as the lex fori or the curial law. And lastly, you could in fact have the law of the place of enforcement. So that would be the 5th aspect. And in certain instances, if this isn't complicated enough, you could actually have a different law with in relation to determining the validity of the arbitration agreement and the scope of the arbitration agreement. Recently, there has been a judgment, well, not that recently, but in 2020, in the case of Enka v. Chubb in the UK, where they have talked about the validation principle on these 2 aspects. It's very complicated. So when somebody asks a question, I'll try and explain this concept a little bit more. Then there is the aspect of when international commercial arbitration is involved versus domestic arbitration in India. Now, in a international commercial arbitration, it's easy to pick a seat of arbitration which is a neutral seat, and this is a very done thing in international commercial arbitration. Let's say I'm an Indian party. There is a foreign party that is based out of England. Parties could say that we want to pick a neutral jurisdiction, which is, say, Singapore. So the seat could be Singapore, and then therefore the supervisory jurisdiction of the Singapore courts happen. But in the case of domestic arbitration, it's very interesting because domestic arbitration would seemingly be governed by the CPC, or not the arbitration, but the aspects of the court-related proceedings would be governed by the CPC. And in ordinary terms, then there would be the issue of the doctrine of ouster. Would the place that is that naturally has jurisdiction in terms of section 16 to 21 of the Code of Civil Procedure, would the jurisdiction be there, or could the parties pick a completely different and neutral jurisdiction? So the Supreme Court, for the first time in Indus Mobile versus Datawind, answered that question to say that the parties could pick a completely different jurisdiction, even where the courts do not naturally have jurisdiction. And this was affirmed by the Supreme Court once again by a 3-judge bench in the case of BGS SGS Soma. So the court, relying on para 96 of BALCO, has brought domestic arbitration and international commercial arbitration pretty much at par as far as this aspect is concerned. So these are my introductory remarks. So if any of you have any questions, I'd like to make this an interactive session. I can then talk about specific judgments as well.
Since we had posted on the social media, we had received a few questions, and we thought we had jotted it down so that we can take those questions. We had narrowed it down, which were very important and which we found to be good. And I feel that when we discuss through the session, a lot of concepts would be cleared, and any cloud which will be in their mind, that will be actually be dispelled with. Now, as the topic itself says, now, Payal, what is the difference between a seat and a venue?
So, Vikas, essentially, seat is what decides supervisory jurisdiction. Now, for the purposes of the audience here, supervisory jurisdiction, let me try and draw an analogy with court-related litigation. So, hypothetically, let us say that let's say, Vikas, you and I were to have a dispute against one another in the court. I live in Delhi, you live in Chandigarh. Correct? In a normal court, in the normal course, let's say our contract provided for the cause of action to arise in Chennai. So according to the CPC, the natural jurisdiction would be either Delhi or Chandigarh, or it would be Chennai, where the defendant resides or where the cause of action is. This would be the natural jurisdiction. Now, it is also a settled principle of law that parties can't confer jurisdiction. So you would have, by the doctrine of ouster, in the case of Hakum Chand, it had been said that the parties can, by contract, pick not confer jurisdiction, but oust the jurisdiction. So by contract, you and I could agree that Delhi would be the place which has jurisdiction, right? So by the doctrine of ouster, Chennai and Chandigarh's jurisdiction would be eliminated. But in Datawind versus, Indus Mobile versus Datawind, and then subsequently BGS, SGS, Soma, says these parties, which is Delhi, Chandigarh, or Chennai, we could actually pick Mumbai as a seat in cases of arbitrations. So now the supervisory jurisdiction means that the courts at Mumbai would have the jurisdiction for appointment of an arbitrator for, let's say, if there was a Section 9 interim relief was required or the award was challenged. All of that would go to the courts in Mumbai. So the either the district court or the Mumbai High Court would have jurisdiction in all these situations. That's the importance of the seat. But venue is, we could have the venue of the arbitration anywhere as per the convenience of the parties, as per convenience of the arbitrator. Now, like we are having this Zoom call, most arbitrations are held through Zoom. So then the question would be, if you did not have a distinction between venue and seat, the question then would be, where would the court supervisory jurisdiction be? Therefore, it is suggested that in arbitration, when you draw up the clause, you should clearly mention the venue and where the seat would be, because seat is very critical to decide jurisdiction of courts.
That you're saying for the purposes when you file objection under Section 34.
Yes, or even if there was a question of appointment of an arbitrator, right? So which is the court that you will go to? And, very recently in 2023, the Supreme Court in the matter of BBR India Private Limited has said, and if I could just read that, once a seat is fixed under Section 22 of the Arbitration and Conciliation Act, please remember not to be confused with Section 20 of the CPC. Once a seat is fixed under Section 20, subsection 2 of the Arbitration and Conciliation Act, it remains static and fixed unless changed by the express mutual consent of the parties. This is a very recent judgment of 2023.
So the next question which would arise is, taking cue from the earlier one, why is it considered to be so controversial that why can't venue simply mean a seat? Why this issue has been created? Like in CPC, we don't see that this concept being boiling down, that what will be the venue, what will be the seat.
So actually, if I could just back up a bit, the issue is actually not as simplistic, but I'll try and explain it first from an international commercial perspective. It'll become easier to understand and then extrapolate it for domestic. So again, Vikas, suppose you were a party that was based in Norway. I was a party that is based in India. We were doing a contract. You are not very familiar with Norwegian law. I'm not very familiar. You may not be familiar with Indian law. I'm not very familiar with Norwegian law. So we pick a neutral seat of jurisdiction. Let's say that we pick Singapore, SEAC, that was acceptable to both parties. Then the challenge of that award would go to Singapore. And only for the enforcement purposes where the assets are, suppose all the assets are based in India, the appeal process would continue in Singapore and enforcement would happen in India. Now, let us say that for ease of the parties, let's say directors and of your company and my company are both based out of London. And we are having all the arbitration in London. The jurisdiction would not go to London. Because oftentimes parties for ease of arbitration can hold arbitration in a different place. So the jurisdiction of the court doesn't travel necessarily as to where the arbitration is held. Now, there was a discrepancy because of Section 21E of the Arbitration Act, along with Section 16 to 21 of the CPC, where the domestic law required, in essence, I don't want to complicate it for the audience, but the domestic law required that the principles of the CPC would govern jurisdiction. So the court in Data Wind said, look, we have the benefit of Section 96 in Balco, where the court has said that the I mean, okay, let me just also explain that Balco versus Kaiser was in the context of international commercial arbitration, but para 96 referred to domestic arbitration. So the court said we want to reduce this entire litigation that surrounds jurisdiction at the start of arbitrations, and therefore we will follow a very similar principle that is followed in international commercial arbitration. I hope it's clear. If there are still questions, please.
Yeah. So in effect, what you have explained to us is seat is linked to jurisdiction, or what is your take on that?
Yeah, it's seat is definitely linked to jurisdiction. It's absolutely linked to jurisdiction. Now, there is a lot of criticism, I must say, for example, of the Indus Mobile case, where even including me, I have to be honest and say that I've critiqued part of it, that it's not in line with the current Arbitration and Conciliation Act. But at the same time, I also recognize that a judgment like Indus Mobile has helped reduce this entire spate of litigations on jurisdiction. Because पहले लेग में क्या होता था विकास, आप जब आर्बिट्रेशन शुरू होने से पहले पार्टी झगड़ा करने शुरू कर देते थे कि कहाँ जाएगा सेक्शन 11, whether it's the appropriate jurisdiction where the parties are residing, where the cause of action has arisen, or will it be in the seat court. So वो सारा कुछ eliminate हो चुका है अब.
Like you have explained this in Hindi, for the we will take this question of seat and venue ultimately at the end again. Now the fourth question is seat treated differently for international commercial arbitration vis-a-vis the domestic arbitration, or are they the same?
It's become the same now post the data wind judgment, but essentially the concept, and I do want to say that the legislature must consider making the judgment of data wind, making a legislative change in the Arbitration and Conciliation Act, ताकि there should be no discrepancy between the law as it exists and the fact that parties should have party autonomy and be able to pick a seat of arbitration that suits them. And the other thing is, which is very critical to mention, is that in India, post Balco's decision, India has become a seat-centric jurisdiction. So what that means is that if the seat in an international commercial arbitration, if the seat is outside of India, India will not have any jurisdiction. But not all, this is not a consistent mechanism worldwide. So there is still a lot of litigation to determine which court will have jurisdiction in cases of international commercial arbitration where the contracts are not clear as to which is the seat court, which is the governing law of the contract, which is the governing law of the arbitration, which is the procedural law of the institutional arbitration. So this continues to be hotly contested worldwide.
Okay. Now, like you said, that there is a lot of interplay of the CPC, that is Code of Civil Procedure. Now, there we see that jurisdiction has been defined very specifically under the Act. Number one, is it defined under the Arbitration and Conciliation Act 1996 with amendments till date? Or you say that there is a separate manner of determining the jurisdiction under the Arbitration Act?
So without getting into the very nitty-gritty of it, Vikas, because it will become super complicated, may I just draw your attention to Section 20 of the Arbitration Act? I've already explained the doctrine of ouster. Now, Section 20 of the Arbitration Act there are three separate sections. So, and all of the three subsections, use the expression place. Can I just take you there for a moment?
Yeah.
So, place of arbitration, it says the parties are free to agree on a place of arbitration. Failing any agreement referred to in subsection 1, the place of arbitration shall be determined by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. Notwithstanding subsection 1 or subsection 2, the arbitral tribunal may, unless otherwise agreed to by the parties, meet at any place it considers appropriate for consultation amongst its members for hearing witnesses, experts, or parties, or inspection of documents, goods, or other property. In Balco also, they had held that subsection 1 and 2 place will be read as seat, and in 3, place will be read as venue. Now, the expert committee once again, in this year in February, has again made the same recommendation, the TK Vishwanathan committee. But the act has continued unamended so far.
Another question arises is, we see a lot of agreements wherein the seat is not mentioned in the arbitration agreement. Then in those cases, how is the jurisdiction decided? In fact, I've just received a YouTube message also by Satinder Mani. He says that अगर ये clause ही ना mention किया हो jurisdiction का, then how do you determine it?
Yeah, this is Satinder ji से आप बताइए कि if Satinder ji is here to hear, this is the most complicated issue worldwide, and I wish there was some way, and I'll just talk about the various decisions in a moment. I wish there was a way to come to some consensus on this issue. At least India ने एक बहुत अच्छा काम किया है. We have made it seat-centric. We have said if the place of arbitration is outside India, we will not exercise any jurisdiction on this issue. Before I come to the other judgments, let me just explain, if I may have a minute, Vikas, to explain just the history for a minute. We had earlier the decision in Bhatia International, where the court had said that unless an agreement specifically says that the jurisdiction, that the part 1 of the Arbitration and Conciliation Act will not apply, India will have would have jurisdiction over that arbitration. Now, Bhatia International had there was a lot of criticism of Bhatia International's judgment. And thereafter, if you see the trend of various judgments that came after Bhatia, whether it was DOSCO, Reliance, Enercon, you could see that the courts were struggling in one way or the other to distinguish the facts of those cases from Bhatia in order to ensure that the Bhatia principle didn't apply. Mercifully, in 2012, in the case of Balco v. Kaiser, a constitutional bench of 5 judges finally said that, look, if the seat is outside of India, India will have no jurisdiction. In fact, the court in Balco went so far as to say that even in cases where an urgent injunction was required, like Mareva injunctions were required, even then the court would not interfere. And they asked the legislature to enact a law, which mercifully, with the 2015 amendments, the court said that you can intervene in situations of Section 9, etc. So with that principle, now one aspect of these 4-5 laws that I had mentioned, that is clarified. But to answer now Satinderji's question, that what happens when seat is not clarified in the contract? What happens in that scenario? In that scenario, we have at the moment, I think 3 different judgments which have dealt with this issue. The first issue, or the first judgment I'll refer to is Hardy. in Hardy Exploration, the court had said that if there is a venue and a seat is not defined, then venue plus one, there has to be one more aspect which is very important. So either the law or the rules of arbitration. So place plus one would convert the place into seat. Now, another three-judge bench in the matter of BGS, SGS, SOMA said actually that they disagreed with the judgment in Hardy, and they said that if there is a venue which is combined with a supranational body of laws, in simple terms, what that means is venue plus the lex fori, or the law of the arbitral tribunals. So perhaps SIAC or LCIA or the NTSC rules. So if you have a venue plus that would convert it into a seat. Now, more recently in Mankastu, and very interestingly, in the matter of Mankastu Impex versus Air Visual, this is a 2020 judgment of the Supreme Court. It had been pointed out to the court that there was a difference of opinion between Hardy and BGS and SGS SOMA. But the court said, look, we are not looking at it, but a place of in the particular facts of Mankastu, the court said that Hong Kong was merely a place. And the words used, arbitration administered in Hong Kong, is actually would amount to an additional indicia, that, and therefore the venue would become the seat, and they held Hong Kong to be the seat, and they appointed the arbitrator. Now, in a more in 2020, in Inca versus Chubb, the courts in England have actually said that if there is an explicit and or an implicit, or implicitly, you could actually see that the parties have made an express choice of law, then the court of that place will have jurisdiction. And in fact, in Enka, the court even said that if there is a governing law chosen by the parties, then the law of the arbitration will follow the governing law of the contract. So the idea is, unfortunately, I don't have a clear-cut answer, but this is the important point that I'm making is that this is a very, very contested area of law.
Now, one question is, what about other countries? For example, how does England find whether they have supervisory jurisdiction on a matter or not?
Can I be a little tongue-in-cheek and say that the history of the laws, that the judgments that I have gone through, England has pretty much changed its position over a period of time, but miraculously in all the judgments, the seat comes down to it being in London. That's a bit tongue-in-cheek. But if I were to just traverse some of the probably the 3-4 most important judgments, which are Naviera, Amazonica, or Sulamerica, and Enka v. Chubb, what the courts in England try to do is to find the closest and most intimate connection to the arbitration agreement. Now, they have formulated the law differently over a period of time, but what in all of these instances, the courts have tried to find out which is the aspect that would make the supervisory court to have the maximum connection with the arbitration involved. So it could be the seat court, it could be the main governing law, it could be the arbitration contract, but a totality of facts.
One has asked, can you repeat the name of the 2020 judgment?
Enka v. Chubb. You want the English case or the Indian one? There are two. The Indian case in 2020 is Mankastu Impex versus Air Visual. This is 3 judges, and then you have in England Enka, ENKA versus Chubb, CHUBB. I'll put it. I'll give you the full name and the citation in the chat box towards the end.
Or you can share it. We will also share it on the website as well as on the YouTube itself.
What I'll do is I'll create a history of the very important judgments, 20 odd judgments that are the most important on this subject, and you can put it on.
You can post it on the website itself.
Right.
Okay, beyond law. And one Dheeraj Mahajan, he's also practicing in Punjab Haryana High Court. He says, could you explain the interplay of the judgment of BGS Soma and Ravi Ranjan judgment?
Ravi Ranjan's judgment, I'm sorry, I haven't seen that very recently. So my apologies, but if there is a specific question, I'll try and answer that.
I'll ask Dheeraj to unmute himself. Dheeraj, you can ask the question directly. Dheeraj?
Hello, am I audible?
Yeah, I can hear you, Dheeraj.
Ma'am, my question was on Ravi Ranjan. The Supreme Court has said that the issue which has been dealt with and decided in BGS Soma, that seat is the Magna Carta where our seat is situated, doesn't fall for consideration in that case. So that is not to be read as the ratio. Because when we apply the principle of BGS Soma in the factual position of the Ravi Ranjan, the answer which has been laid down by the Supreme Court in Ravi Ranjan runs contrary to what BGS Soma says. So there is a contrary views. BGS Soma is prior in time, Ravi Ranjan came later in time by Justice Indira Banerjee, specifically saying that BGS Soma is not laying down the ratio of law on the point which is being dealt with. So that was the issue which was coming in my mind. As rightly said by you that there is a gray area in the law where seat is not situated, how to determine the jurisdiction. In Ravi Ranjan, the agreement was executed, I believe, in Bihar, work executed in Bihar. The agreement says that arbitration proceedings to be held in Calcutta. Calcutta High Court appointed an arbitrator. The Supreme Court set aside, no, that was not the intention of the parties. Section 9 filed in Bihar, work executed at Bihar, everything done at Bihar, so Bihar would be having the jurisdiction. So this was the question coming in my mind, that if we apply BGS Soma, then it runs contrary.
Yeah, I recall this aspect. I recall this judgment. I haven't seen it recently, Dheeraj, but let me again try and explain.
It was just a question since I was a part of this discussion, so
so let me just try and explain. There is a discrepancy between the way the Arbitration Act reads and the way BGS SGS Soma has dealt with the issue. Since you brought it up, I may not be able to answer your specific question, but let me, if you can just take section 21E for a minute.
Yes, ma'am, I have read it many times.
Yeah, so you know what the issue I'm talking about. So the criticism is arising from the fact that 21E is in the teeth of Indus Mobile is in the teeth of 21E. That's the issue. And also the fact that Balco is 2012. There is the issue of para 96, which is, in my opinion, obiter dicta. because BALCO is dealing only with respect to international
Yes,
commercial
yes,
arbitration,
yes,
right?
yes, yes, yes,
You
yes,
have
yes,
the 2015 amendments which do not amend 21E.
yes,
And
right.
in Indus Mobile, what the court has said is that, most respectfully, the court said that we are using para 96 because it's a constitutional bench
That is
judgment,
it.
and the
That is
court
it.
is assumed to have. So I agree with you
But
that and I started out saying this, that there is some discrepancy. However, I've also written about this, that we shouldn't rush to overturn data win and BGS, SGS, SOMA in regard to domestic arbitration, because just see the spate of litigation जो jurisdiction which has been completely eliminated.
right, man.
Uh,
Hope some better position of law would come.
yeah.
Thank you.
Dheeraj knows it very well that nothing is permanent except the change. So before we conclude for this, Payal, could you explain the seat and venue in Hindi so that those who are watching the session can understand, those who are well versed with Hindi?
हाँ, मैं कोशिश जरूर करती हूँ. वेन्यू जब आर्बिट्रेशन होती है, वेन्यू सिर्फ उसी उधर तक ही लिमिटेड है जहां पर आर्बिट्रेशन एक्चुअली जहां पे आर्बिट्रेशन एक्चुअली हो रही होती है, और सीट जो होगी उससे डिटरमिन होगा कि कौन से कोर्ट में आप अपील फाइल करेंगे या कौन से कोर्ट में जाएंगे आर्बिट्रेटर अपॉइंट करने के लिए, अगर पार्टीज अपने बीच में कंसेंसस पे अराइव नहीं कर सकती किसी आर्बिट्रेटर के लिए, या अगर आपको कोर्ट जाना पड़े किसी इंटरिम ऑर्डर लेने के लिए. तो ये डिस्टिंक्शन है. और वेन्यू सिर्फ उससे कोई फर्क नहीं पड़ता कि कौन से कोर्ट के पास जुरिस्डिक्शन होगी. अगर आपने सीट नहीं डिसाइड करी है तो आप आर्बिट्रेटर के पास, जब आर्बिट्रेशन शुरू होती है तो पार्टीज अग्री कर सकती हैं कि हमने डिसाइड करा है कौन सी जगह के पास सीट होगी और कौन से कोर्ट के पास सुपरवाइजरी जुरिस्डिक्शन होगी आर्बिट्रेशन की. और एक बारी आपने ये सीट को डिटरमिन कर लिया, फिर इसको आर्बिट्रेटर भी नहीं चेंज कर सकते जब तक कि दोनों पार्टी म्यूचुअली अग्री नहीं करेंगे इसके लिए. I hope that was clear.
So thank you, Payal, and I'm quite hopeful that people will have their doubts clear. And as we had discussed with Dheeraj also, that this is a transition and there's a lot of discussions going on. We also have certain matters of NHI pending before the court. Let's see how things evolve and just share those set of judgments. And thank you for sharing your knowledge. Thank you, everyone. Stay safe, stay blessed. Bye-bye.
Thank you.